Okay. Hi, everybody. I am Steve Levitsky, Director of the Rockefeller Center for Latin American Studies at Harvard. Welcome to our final Dr. Class Tuesday webinar of the year. I want to thank the many of you, many numerous members of the Dr. Class community, both in the United States and across Latin America, who've been regularly attending our sessions and participating and asking great questions. Zoom sessions are no fun, but as far as Zoom webinars go, these have been a really interesting and fun set of sessions, and I want to thank all of you for joining us. I should note that we will very likely be continuing this webinar panel format at least in the fall semester when we get back. All right, so this week's panel, wrapping up the semester, is entitled Reforming Chile's Constitution, the Debate Over Social and Economic Rights. Before we jump in, I want to thank our amazing team of Paola Ibarra, Jillian Scales, and Gabrielle Patterson for making this event work. I also want to introduce to you my two wonderful co-hosts, Alicia Holland and Francis Agopian.
Hi, everyone.
We've got a terrific panel today. Before I introduce our four speakers, just a couple of brief housekeeping items. First of all, translation is available for the event today. If you just go to the interpretation function at the bottom of your screen. Second of all, we are recording today's webinar, and it's going to be available via the Dr. Class YouTube channel shortly after today's session. Third, if you've got a question for any of the panelists or all of the panelists, you may send it through the Q&A tab at the bottom of your screen. The chat function is closed down, but if you have questions, just send them through the Q&A function at the bottom. You can do that during the talks. You can do that after the talk. At any point, just send in your question, and we will be feeding questions to the panelists after their presentation. We should have about 30 minutes for that, and we'll close the session at 1:20 or 1:25. All right. Next month, Chileans will elect a new constituent assembly charged with replacing the 1980 Constitution. This constitutional change process was the product of a massive civic uprising that began in October 2019, in which more than 3 million Chileans took to the streets. In a referendum held in October 2020, nearly 80% of Chileans voted in favor of writing a new constitution. Not surprisingly, this process has triggered quite a bit of debate, very interesting debate about the substance of the new constitution. One of those debates centers around the role of social and ethnic rights, or social rights broadly defined. The 1980 Constitution is pretty old school. It's fairly minimalist. It grants classic liberal rights, not too much more. And there's been a push, particularly among progressives, to make this new constitution much more expansive by including a wider range of social rights. And given that the 2019-2020 protests were at least partly driven by discontent over issues of inequality and low social mobility, this shouldn't be all that surprising. It shouldn't be surprising that there's been demands for a more expansive constitution. But on the right, there's concern that a more elaborate constitution will undermine Chile's vaunted free market economic model, and that too many social rights will, in the long run, undermine economic growth. And that's what we're here today to discuss. We have four outstanding panelists. Let me briefly introduce the four of them and then let them go, or let them speak. First, and they'll speak in this order, which is alphabetical order. Daniel Brinks is professor of government and law and chair of the government department at the University of Texas at Austin. His research focuses on the role of the law and the courts in supporting or extending democratic rights, especially human rights, across Latin America. He has written or edited several books on this subject, including The Judicial Response to Police Violence in Latin America, Inequality and the Rule of Law, that was published a while ago now by Cambridge University Press. He's also co-editor of Courting Social Justice, the Judicial Enforcement of Social and Economic Rights in the Developing World. And he's currently writing a book on constitutional change in Latin America since 1975, which focuses on the evolving role of the courts and constitutional review. I should add that he co-edited recently an outstanding book on the politics of institutional weakness in Latin America, along with Vicky Murillo and some other guy whose name I can't remember. So welcome, Dan. Second, we have Rossana Castiglione, who's professor of political science and dean of social sciences and history at Diego Portales University in Santiago, Chile. Her research focuses on comparative social policy and dilemmas of democratic representation in Latin America. She's emerged over the last, I guess, couple of decades as one of the leading experts on social policy in Latin America. She's published widely on the topic, including her outstanding book, The Politics of Social Policy Change in Chile and Uruguay. Welcome, Jefa. Veronica Figueroa is a Mapuche professor with PhD in Management Sciences from ESADE. She's associate professor at the Institute of Public Affairs at the University of Chile and author of the prize-winning book, Formulation of Indigenous Public Policies in Chile, Evidence of a Sustained Failure. Professor Figueroa has been a postdoctoral fellow at Stanford, and last year we had the honor of hosting her as a visiting fellow at Dr. Klass. Professor Figueroa also serves on the advisory council of Dr. Klass's academic forum for a new constitution in Chile. Welcome, Professor Figueroa. And last but certainly not least, Cristian Rodriguez is Dr. Klass associate working on a project entitled Foreign Investment in Times of Civil Unrest and Constitutional Change, which focuses on the case in Chile. He has served as executive director of Invest Chile, Chile's investment promotion agency, as well as head of international trade and investment policy at the World Economic Forum. He is, in addition, worked as the lead trade and environmental negotiator for the Chilean Foreign Affairs Ministry, where he worked, among other things, on the Trans-Pacific Partnership deal. Cristian also serves on the advisory council of Dr. Klass's academic forum for a new constitution in Chile. So welcome and thank you, Cristian. Okay, we will go in alphabetical order, which means we start with Professor Briggs.
Thank you, Steve, and thank you for inviting me to participate in this. It's always a great conversation, especially when I share the panel with Chilean scholars who obviously know way more about the situation in Chile, the aspirations and the fears that are getting built into this whole constitutional process. So I'm really looking forward to our conversation today. And what I'm going to do to start us off is to just a couple of things, and they're mostly sort of from a more global perspective rather than a particularly Chilean perspective. So the first thing I'm going to do is to try to situate Chile, or Chile's constitutional text in particular, in global and regional context. And then I'm going to say some things about what it means to include social, economic, and cultural rights, what we often refer to as ESCR or ESC rights in your constitution. So let me start with that first thing. And for that, I'll just quickly put up just a couple of slides that should give us a sense of kind of how Chile looks compared to the rest of the region. So, so if we look at the long period of sort of written constitutionalism in the world, right, beginning with the U.S. Constitution in 1787. So the early constitutions essentially mostly had no social rights, no social guarantees in them at all, right? So the early constitutions were mostly about creating frameworks for governance and more or less avoided substantive commitments. Even our own constitution, right? Our Bill of Rights is a series of amendments to the original text, right? So you can see kind of that impulse to keep the constitution as just a framework for governing. And then, you know, in the 1900s, you see an uptick of the beginning of guarantees of social and economic rights, mostly the right to healthcare, the right to education. Those are early rights that show up. Some rights to social provision, particularly in old age. And then much later, things like the right to a clean environment and the rights of children and the right to housing and the right to work. The right to work begins to show up around mid-century, but there's this sort of proliferation, explosion almost of social and economic rights in constitutions, sort of with the post World War II, sort of post-colonial constitutions, and then again another bump up in the post-Cold War era, right? You can see this, the sort of the two spikes after 1950 and after roughly 1990, right? So that's taking a very sort of dichotomous approach, saying either you have none or you have some, right? But when you look at the number of social rights and constitutions, you see a similar pattern, right? So a jump around 1950, shortly after, and another huge jump around 1990 or shortly after, in just the number of social rights, right? So there's a sort of proliferation of the sorts of things that are guaranteed in constitutions. And along with these guarantees of rights came more attention to the mechanisms for making them effective, right? So in later constitutions, what you see is more attention to judicial enforcement mechanisms. And here's where you really see sort of Chile as an outlier, right? So Chile has a constitutional court as well as a Supreme Court, which has some constitutional attributes, but it has a constitutional court that has a lot of the sort of authorities that we've been giving constitutional courts lately. And we don't have to get into too many details. It's just as you move from left to right on this scale, your court has more capacity to intervene in almost a policy-making manner, right? To strike down laws, to make broadly binding policy-like decisions, right? So as you move from left to right, your court acquires more attributes, and as you move from bottom to top in the graph, you have more economic, social, and collective or cultural rights to enforce, right? And so Chile has a court that has significant constitutional attributes, but it just doesn't have a lot of ESCR to enforce, in contrast to almost every other country in Latin America. So what does that mean? My mother always used to say, just because everybody else is jumping off a bridge doesn't mean you should jump off a bridge as well, right? So the question I think for Chile is, just because everybody else is doing this, right? Is this something that we should be thinking about as well? And I think to make that decision, you really have to think about what it means to move something, say healthcare or education or whatever, from the sphere of ordinary politics into this other sphere, that's the sphere of say, constitutional justice, right? So I think the first sphere is what Steve alluded to in the introduction, which is, I think the first thing that people imagine when they think of moving something into that space of making it a right and putting it into constitutional justice is that there are going to be no limits to the demands under it, and there are going to be no sort of ability to do trade-offs, right? So you can't trade off healthcare against some other value, some other goal, because now healthcare is a right, right? I'm not going to spend a lot of time on this. There's a ton of literature on what the courts have done and how they've enforced these rights, but I think it's pretty clear. I mean, we've seen now from research around the world that courts have found lots of ways to incorporate trade-offs, both through concepts like progressive realization or using the maximum available resources, or through interpretive techniques like balancing, where they balance competing interests, or like the South African Constitutional Court, which has adopted this strong version of sort of reasonability analysis for evaluating the decisions of the ruling coalition in these areas, or even the sort of stricter minimum core analysis sort of still allows a lot of space for decision making once you get past sort of minimum guarantees. But I think, especially at the constitutional moment, and especially in Chile in some ways, the greatest fear in incorporating ESCR into your constitution is that you're giving up control. You're losing your politics on these issues, and you're turning them over to judges and converting them into purely legal questions. And my sense, and my own, so the last book I wrote makes this argument pretty strongly, that is that you're not subtracting these issues from ordinary politics, right? What you're doing is you're adding another layer of institutions, of discourse and rhetoric, of actors, of decision makers, right? That make it a sort of more densely governed space with lots of different decision spaces and lots of different actors, but not a place that's free of politics, or even a place that's independent of our ordinary politics and beyond our control as majorities. But part of the fear in Chile comes from the existing constitution, right? The existing constitution has these issues that it sort of locks away using supermajoritarian decision rules, right? And so people in Chile, I think Fernando Atria has been at the forefront, or, you know, and others as well, would say, look, what we need is not to create more checks on majoritarianism. We need to let the people of Chile be free to govern, right? Let's not put the courts in charge, right? And I think, you know, I'm more sort of in the camp that says that one of the Guatemalan, 1985, Guatemala wrote its first sort of pre-democratic constitution for the current era. And one of the assembly members said, in talking about constitutional justice, he said, it's justice, but it's political justice, right? So what does that mean? I mean, I think what that means is that in the space of constitutional justice, the ruling coalition, the majority act, they're often the first actors, right? They'll put out some version of health policy, you know, education policy, even some version of a law governing, say, territorial autonomy for indigenous peoples and so on. So they're still the first movers, but then that decision is subject to a bunch of reviews, right, or checks. It's the political representatives and the legislatures that are one important and relevant decision space, but minorities with constitutional demands, organized civil society in particular, gets a loud voice when you're working in constitutional justice. Lawyers and judges get to add their own views of what should be done, what needs to be done, what can't be done. The key decision-making spaces are not just the legislatures, but also the courts. And even electoral accountability doesn't disappear, right? We know from our research on courts and compliance with judicial decisions that it's actually, you know, popular support and often electoral support that determines how much freedom the court has to move things in a particular direction, right? And we know also just from looking at different countries and how things evolve, is that even the courts are sort of subject to ex post electoral accountability, in the sense that if judges are pushing too far in one direction, we eventually get to replace them with judges that are going to go in a different direction, right? So even here, judges don't have the final word. So what's different, I think, in the space of constitutional justice is that binding decisions result not from purely majoritarian decisions, which are often truly not that majoritarian, but they're representative at least, right? They're processed through our representative mechanisms, right? And in the space of constitutional justice, these binding decisions result from this complex dialogue between majorities and minorities, between legal and political elites, between publics and organized civil society, between activists and representatives, right? So what it does is sort of elevate a number of voices that don't have quite as much strength in the space of ordinary politics. So I guess what I would say is constitutionalizing an issue implies not so much subtracting it from politics, but adding all these actors, institutional spaces, discourses, and logic. There's also something we could talk about later in the Q&A, which is a lot of times ESCR are constitutionalized, but not made justiciable, right? And in that case, they're really just empowering and almost demanding the majority to act in a particular area, but not really kind of creating that other layer of oversight. So Chile, like any other country, thinking about writing a new constitution has to decide where the demands for ESCR fit, right? They don't go away. The demands for education, for healthcare, indigenous people's demands for territorial autonomy, they're not going to go away. The question is, where are they going to be? Are they going to be in the realm of ordinary politics, right? Where the interlocutors are the main political parties and representatives and lobbyists and that sort of thing? Or are they going to be in the field of constitutional justice, where you add this other layer of actors and accountability? Or maybe in the intermediate space, right, of constitutional politics, where you've added the discourse of rights, but you haven't sort of turned it over to the courts. So why do it in the end, right? I mean, I've given you reasons, I think, or at least we could talk more about it, but I think there are lots of reasons not to be too afraid, not to be too afraid that ESCR are going to break the bank or evacuate politics of any meaningful substance. I think the inclusion of these rights in recent constitutions is a recognition of and a response to the demands that people had who felt left behind by the current model of development. In particular, if you look at the demands for indigenous rights, they're often as much symbolic as material, right? They're often as much about recognition and inclusion as they are about getting particular goods, particular things. And so including ESCR in your constitution is in some ways a recognition that the state has for too long failed in these areas. They failed to provide decent healthcare or education or a clean environment or work or housing, right? Or so many issues, right? And at the end of the day, you know, whether you put them in the Constitution or not, as one of the drafters of the 1994 constitutional amendments in Argentina said, at the end of the day, your work on these issues, and in particular your work on rights that you've included in the Constitution, is not done when the Constitution is signed. That's just when it begins.
Thanks, Dan. Dekana, you're up.
Okay, thank you very much. I'm going to share my screen very quickly. So I think, yeah, my screen is there. Well, thank you so much for the invitation. Thanks, Fran, Alicia, and Steve for having me here. Although, however virtual this visit to Dr. Glass might be. I'm going to center my presentation on the difficulties associated to turning social demands into social rights. I'm not going to talk about indigenous rights because we have Veronica here, who is the true expert. So I will center mostly on social rights, that is closely related to my field of expertise. So, as you know, Chile experienced a dramatic process of politicization or repoliticization of inequalities and social rights that started in 2006, I would say, with mobilizations of high school students. It peaked in 2011 with university students mobilizing for equality in education. And then it continued with different waves of mobilizations associated with different type of rights, you know, pensions, the environment, and so on. So what is that Chileans want is, it's a difficult question to answer because there are several different grievances and demands associated with these mobilizations that peaked in 2019 with the so-called social explosions. And I think this picture of protesters saying we want a new constitution, we want respect for transgender people, health, labor, education, justice, housing, rights, abortion, and probably if the page were larger, we will see more rights including there. So there are several different demands clashing in the public space without an actor putting them together. If you look you go to more to the specificities, we know that the social explosion started with a demand of, against the increase of the prices of public transportation, but that was not the issue at all. In some regards, there are broad demands, such as, for example, a demand for dignity, which is very difficult to translate into a new constitution. But then there are very specific demands. For example, first salaries, elimination of the private administrators of pensions, more budget for healthcare, and more recently, a process of politicization of social structural rights and social structural demands, for example, gender equality, indigenous rights, and even social class and territorial inequalities. If you look at the public opinion polls, you will see that these demands translate very clearly into what Chileans think are the problems of the country. This is the result of a public opinion poll from October 2019, so at the moment where the social explosion took place. And if you see, for Chileans, the most pressing issues are pensions, inequality, healthcare, unemployment, salaries, and education. So with the exception of delinquency and corruption that are identified as important issues for Chileans, most of the issues are related to social rights and social policy, social protection. So this is clearly one of the issues that has been going on in the country. However, I think there are several difficulties associated to the translation of these social demands and grievances into social rights in the Constitution. So from here to there will be a very long way. What are these difficulties? Well, first has to do with very low levels of legitimacy of political actors. So to put the social explosion into perspective, in a country where 3.8 million Chileans voted for the current president, 4.3 million Chileans mobilized from October to December 2019. So we are talking about a huge movement pushing for change. However, this also has been happening in a context in which institutional mechanisms to process discontent are increasingly being, I don't know if disregarded, but going down also. So electoral participation was really high in the transition to democracy, around 80%. Now we are around 50% of turnout. And UNDP wrote a report in 2017 that they say that during the past 25 years, Chile has exhibited the second largest drop of electoral participation worldwide, only surpassed by Madagascar. So we are talking about, even if you put Chile into global perspective, the drop in electoral participation is quite dramatic. Also, all this process, has been tied to a dramatic drop in the levels of party identification. In 1983, 70% of Chileans identified with political parties, and in 2000 is around 14%. Now, this is the worst. Trust in formal political institutions. Is around 5%, trust in Congress 3%, and political parties 2%. So I always put the example, if you ask in a public opinion poll in Chile, what is your support for, I don't know, drug cartels, probably you will obtain a similar percentage than you get with political parties. It's really, really low, and it's really, really dramatic. We need political parties involved in this process. So it is impossible to create a new constitution and push for changes without political parties, but we have to acknowledge the fact that political parties and political actors are not trusted and have very low levels of support. Now, what I think is the most difficult issue related to this process of translating social demands and grievances into social rights in the Constitution has to do with the fact that pro-change forces, I mean, those forces that are really into promoting structural changes in the country, are highly fragmented. So center, left and left-wing parties are extremely fragmented and have been unable to coordinate efficiently. And on the other hand, pro-status quo, the gatekeepers of the current 1980 constitution have been highly coordinated and are highly cohesive. My colleague, Claudio Fuentes, has been following a lot this issue, and he claims that there has been a very efficient coordination of center-right political parties with business associations and conservative think tanks along, trying to identify what are the key issues that they want to maintain or to change. So this coordination is going on. We don't know what the results of the election for conventionals is going to be, but I wouldn't be surprised if conservative forces are the winning forces in the convention. That's a risk. A risk in terms of we have a push for, asking for structural changes. And the other problem is that these social rights or the demands of social rights is something that is also tied to structural roots. For example, if you want to close gender gaps or if you want to close gaps, for example, of the lower representation of indigenous groups, have structural roots. So even if I am an institutionalist, if you change the constitution, probably the basis of these problems are not going to be solved. So is all of this bad news? Well, I think it's something good and something that we should hope for. The 1980 Constitution is a sinful constitution. It was, there is an original sin associated with the 1980 Constitution. This Constitution was produced in a dictatorship without deliberation of any type. So for a big percentage of Chileans, this is an illegitimate constitution. So as these protesters say, against winds and COVID, Chile decided to end the legacy of the dictator. Legitimacy is very important, and we know because of the research of political psychologists that when people believe that the decision-making process is legitimate, they are willing to accept the outcomes, even if the outcomes are harmful, even if the outcomes are not the outcomes I wanted. So legitimacy is important, and I think this might be one of the important results of this process. So, to conclude, what is, I think that we can see this process have full or half empty glass, we can be optimistic and we can be pessimistic at the same time. I think there is room for optimism because I hope and pray that the legitimacy problems of the 1980 constitutions will be solved because it's going to be a democratic constitution produced through deliberation, and this is not a minor issue. This is not an unimportant issue. This is important in itself. Now, in terms of the half-empty glass, I am really worried about the heterogeneity of grievances and demands from Chileans. Before this presentation started, I said I was afraid of the revolution of growing expectations. People are expecting a lot from this new constitution. And I think that one of the problems is also that these progressive pro-change forces are highly fractionalized, have been very inefficient in coordinating. So I am not sure that we will see the changes that Chileans expect. So thank you so much. I will stop sharing my screen and I'm back to you.
You university administrators are so disciplined with your time. Thank you, Roxana. Third speaker is Professor Veronica Figueroa. You there?
Thank you so much, Stephen. Thank you for this invitation. Thank you also for opening this important space to indigenous voices. I want to share some ideas about the relevance of Chilean process from the perspective of indigenous people. The current constitutional process in Chile is historical for several reasons. First, the new constitution will be discussed through a convention integrated by representatives elected by the citizen. Second, it will have gender parity. Third, indigenous people, we will be participating through the reserved seats mechanism, recognizing, at least in part, the depth of Chilean nation state and promoting, for the very first time in our history, our participation as political actors. According to Chile's census of 2017, 12.8% of Chileans declared themselves belonging to an ethnic group, totaling more than 2 million indigenous people. The Mapuche people are the majority, comprising 79.8%. As in other Latin American countries, Chile follows a nation-state model which denies the pre-existing nations made up of the indigenous people. This gave rise to a state designed by a society that ignores indigenous people, constructing an idea of a homogeneous nation where the egalitarian citizenship share the same aspiration. This narrative was used to exclude the recognition of political rights for indigenous people and obscure our demands. It should note that Chile has been one of the countries in Latin America that least advanced in recognition of the rights of indigenous people. Even when Chile has ratified international agreement, this constitutional process finds out without constitutional recognition and no political representation at any state level. We don't have representation in Congress or a Ministry of Indigenous Affairs, or the right to self-determination, nor autonomy, as indicated in the United Nations Declaration on Indigenous People. For that reason, we have the opportunity not only to put our voices, political demands, and proposals in this political space, we also have the opportunity to change the distribution of power. Our proposal goes from to recognizing Chilean state as a plurinational state to advancing the recognition of environmental protection, self-determination and autonomy, and the recognition of our cultural and social practices, among others. Which are our proposals? First, a plurinational state. A plurinational state implies the recognition of different nations inside of the Chilean state. Give them all the opportunity for political representation and participation in the construction of our own social and political institutions. This does not imply the supremacy of one nation over another, but rather the search for new forms of participation and definition of the rules of the game based on respect and equity. If the nation is the conscious unit and reflects a united people, the state is the legal and political structure of this unit as such. In this sense, the new constitution could indicate that Chile is a plurinational state or a state composed of a community of nations, or declare that its sovereignty rests with the nations that inhabit Chilean territory, integrated by the Chilean people and indigenous people. This declaration needs to incorporate interculturality as a principle that governs all the rights defined in the new constitution, ensuring that all nations will be respected equally. Second, we want self-determination and autonomy. Related to this, the new constitution has to recognize the right of self-determination and autonomy. In accordance with the United Nations Declaration on Indigenous People, states must create institutional adjustments so that these people can freely establish their political status and pursue their economic, social, and cultural development. Likewise, states must also respect indigenous rights to promote, develop, and maintain our institutional structures and our own culture, spirituality, tradition, procedures, practices, and where they exist, customs or legal system. Therefore, the Constitution must establish our right for autonomy to resolve our affairs and regulate the fundamental aspects required for the survival of our ways of life. In Latin America, several constitutions have recognized the right to autonomy. An example is the Bolivian case, which states that given the pre-colonial existence of indigenous people and their ancestral control over their territories, their self-determination is guaranteed within the framework of the unity of the state, which consists in their right to autonomy and self-government in accordance with this constitution. The Mexican Constitution does the same by expressly establishing the right to self-determination of indigenous people and establishing autonomy as the political and legal form for the exercise of this right. The Chilean Constitution must consider different factors, such as the predominance of shared territories, the mixed nature of the population in many of them, and the concentration of indigenous population in urban areas. Also, it must be determined which territories in Chile that could be defined as spaces of territorial autonomy. For that, the Constitution has to establish that a special law will regulate dialogues with indigenous people to establish these autonomous territories. Third, other rights important to indigenous people. From the indigenous proposals, constitutional recognition of a plurinational state with indigenous self-determination and autonomy would allow progress in the recognition of new political representation and cultural or linguistic rights, among others. When establishing the rights that will govern in this constitution, it must be ensured that they comply with intercultural criteria. For example, the right to use our own language in public spaces, our right to be educated in our own language must be recognized. Also, the right to intercultural health and the necessary respect and recognition of our ancestral authorities. The new constitution has to establish the duty of the state to protect medicinal plants, seeds, and indigenous traditional knowledge, especially ecological ones, but in general, all the cultural heritage of indigenous people. Some final reflections. We know that our proposals are difficult to install, mainly due to the lack of knowledge of our rights. The recognition of our rights affects the economic interest in our indigenous territories. For this reason, the regulation of the Constitutional Convention are also relevant. Dispute resolution mechanisms and discussion systems must not affect the right of participation and representation of indigenous people, especially those who have obtained reserved seats. The regulation must establish the right consultation and information to indigenous people before the final approval, respecting the deliberation mechanism. Finally, we invite Chilean society to see our participation and proposal as an opportunity for a new governance model, where the Earth Mother is recognized as having these rights. Firstly, the value of equity. Secondly, that the collective way of life is better than individualism. Thirdly, the respectful relationship with our environments. And finally, the intergenerational equity. We can't forget that someday we will be the ancestors. Thank you very much.
Thank you so much, Veronica. Fourth speaker, Cristiano Rodriguez.
Señor, I'm going to come here from a little bit of a different perspective, as Steve gave me the very dry, unpopular, and unrewarding task of talking about who's paying for the bill of all this, of a discussion relating, of course, all of these social demands, but how do we actually maintain the ability of the country to keep generating growth and attracting investment and foreign capital needed to satisfy these social demands, right? I'm going to start from the basis that sustainable foreign investment brought into an economy in a responsible manner is a good thing, creates wealth, employment, etc. Because if we go into the discussion of is it good or not, I think that's a whole different panel. So we'll assume that. I'm going to center into issues really. First, how are these demands viewed from the angle of international investors? And second, what are the limitations that these economic issues present to the work of the Constitutional Convention in terms of international agreements? So I'm going to take, Steve asked me, also a practitioner angle. As he mentioned, I was the head of the Chilean Investment Promotion Agency. So before and during the estallido, and well into the pandemic, my job was to basically accompany foreign investors into the country. But after October 18th, 2018, my job switched overnight from attracting foreign investment to keep investors in, and I think this is very important because it's relevant, because it can also provide leads on what does it take to maintain that foreign capital and maintain investors to stay throughout all this constitutional process, which is going to take, of course, a couple of years. First, as of 18th October, due to the riots, burning infrastructure, lack of governance, we struggle with this. But then after November 15, 2019, the date of the Acuerdo por la Paz Social y la Nueva Constitución, also due to this uncertainty of what we're discussing now, a full reshuffling of the cards, an upcoming of a new constitution, the uncertainty of the drafting process, etc. Then, of course, came COVID, which in a way softened the constitutional process a little bit in terms of the demands from foreign investors, because it was no longer a Chile crisis, but a global crisis. But in any case, any constitutional process is risky in the sense that it creates expectations. And so far, I think the lack of constructive dialogue, notwithstanding political difference, has only enhanced polarization. So the first question that people looking at us from abroad, including international investors, will have for us is, will we be able then to live up to these expectations? The first questions that we got from the foreign investors, when confronting a process like Chile, started on October 18, 2018, and continues now, I think it needs to divide from short-term and medium to long-term. In the short term, what they want is information. You need to be proactive, you need to contact them, you need to provide information. And I think for the government, defensively, it needs to have, and this comes to my second point, I'll take on later, it needs to have clarity on the international rules binding the states. And that's international treaties, free trade agreements, on which I'll come back to. And then in the medium long term, it's very important the way in which the constitutional process is managed, maintaining the rule of law. I think Chile, in spite of the shortcoming of the discussions of La Clase Política, still has managed to maintain this rule of law. We're going through an institutional way out of this constitutional drafting process, because all countries change rules. The question is how, right? Calculated risks are okay for investors. What is not okay is when you're changing the rules all the time. So first and foremost, let us agree on something which should come as pretty obvious, but let's say that establishing a good track record of a country in terms of international trade and of treatment of foreign investors is good, not only for the present government, but also for those governments of the past and governments of the future. And I'm saying this because I just want to bring a few numbers. According to CACEN, poverty in Chile went down from 68.5% in 1990 to 8.6% in 2017. In the same period, GDP per capita went from less than $5,000 to over $25,000. And of course, if we take inequality and the Gini coefficient that we all know, it went from 0.57 in 1990, being one most unequal, to around 0.45 in also in 2017. This is still a lot, but there's also an improvement there. You can see it in COVID-19 management. Of course, the cases are still really high, but Chile is on top of the global vaccination effort, and this is because the country works. Regarding of what kind of government will we have, I'm sure that the country would still be in this position because we have this solid institution that we've been able to build through the last 30 years. So I understand that this doesn't speak to folks trying to burn General Baquedano at Plaza de la Dignidad, but it does speak to foreign capital that creates employment. And of course, I'm not saying that poor income distribution, low pensions, and the deficiencies of the public health system were acceptable. Quite the contrary. My point here is that connecting back to social demands and social aspirations is that the country needs to remain economically viable to sustain this democratic renewal. Getting our new constitutional rights is important not only in terms of Chile, but also of this constitutional exercise as a footprint for other Latin American and even global nations that may undergo a similar experience. Here at the Foro de Harvard para la Nueva Constitución, we highlight that one of the foro's goals is to share Chile's democratic constitutional drafting experience with our audience in Latin America, as also their own countries may confront similar refundational processes in the future. With this, I would like to move to the second point set out at the beginning of my remarks, which is the issue of the limitations that exist in international treaties to which Chile is a party, such as free trade agreements and investment protection treaties, present to the convention's drafting. The constitutional reform that proclaimed the ballotage and the convention established a new Article 135 of our current constitution, which states that the new constitution will, and I quote, respect the fact that Chile is a republic, it's a democratic regime, the firm court decisions or res judicata, and very relevant to this part of the discussion, the international treaties will respect the international treaties that have been ratified by Chile and that are currently in force. Even before the addition of this article, there was ample discussion in Chile with regards to the legal constitutional status of these international treaties. Even the Supreme Court and the Constitutional Tribunal have manifested dissenting views regarding if these treaties are at the same level of the Constitution or these international treaties are just above the laws, but under the Carta Magna. Certainly, this discussion will be translating into the Constitutional Convention. And relevant to my remarks here is the question of what are the limitations that, in particular, economic treaties, namely the 30 free trade agreements with more than 65 countries that Chile has in force, plus an even larger number of investment protection treaties, bring to the convention? What are the limitations that this bring to the work of the Constitutional Convention? And I think in practice, the question here is, what will happen if the convention determined that a good is no longer subject of private property or concession, but these property rights are otherwise protected by an international agreement already ratified by Chile? And here, arguably, the state could become internationally liable and be sued before an international court for compensation. And here is where, in particular, international treaties regarding the protection of foreign investment become relevant, as they not only confer the possibility of opening a case between nations for a breach of a treaty provision, so state-to-state disputes, but also investment treaties enable individuals or companies to sue a sovereign state due to unlawful expropriation, discriminatory treatment, and others, if you know, before exit or CIADI, which is called in Espanol, the tribunal that enables private companies to sue sovereign states. Question is this an absolute deal breaker for the inclusion of new constitutional rights or the limitation of existing constitutional rights, which will affect the property of rights of foreign investors, which have already established in Chile? And I will say, evidently, no. Chile, first, as a sovereign nation, could put an end, denounce in legal jargon, any treaties which is inconsistent with this new constitution, right? But this is not automatic. Some of them have survival clauses, in particular the investment treaties, that drag them along for as far as for 15 years with regard to the protections for investments. But most importantly, in general, these investment protection treaties always allow for expropriation as long as proper compensation to the foreign investor is provided by the state. In other words, even should we suffer a specific nationalization or a good or a sector, this wouldn't automatically trigger an investment protection mechanism of the treaty because the state will always have the right to first duly compensate. I know this sounds quite dry, a little bit of a off conversation to the central topic, of the rights that we are discussing today. But the truth is that Chile is always fighting between number one and number two of the countries in the world that have more free trade agreement and more investment protection agreements. So this is a reality on which we are immersed into our international legal framework. And I think we both have to acknowledge it, but also we have to de-dramatize it, because I think it's totally feasible to draft the constitution that we want from this convention, including that constitution and that norm keeps afloat our international commitments as of today. These economic treaties go far beyond investment, and they center also on trade rules, tariffs, environmental labor standards, regulatory issues, cooperation, etc. Before I finish, I would just like to refer to a particularly controversial economic treaty that has been widely discussed lately, including during the Estallido Social, the Trans-Pacific Partnership, or the TPP-11. We all, if you were in Chile during the Estallido, I'm sure you saw at least one or two big signs that said no al TPP-11, Setting aside the political implications, I'm not going to get into that, technically, pure technically, and having actually negotiated a treaty in the past, the treaty does not add any further liability or quote unquote dangers of responsibility to the Chilean state than what Chile has already enforced with the same countries today. As a matter of fact, Chile has free trade agreements in force with all the other 10 countries of the TPP-11. Okay, one could ask then, what is really the added value of subscribing it there? And there I would argue that perhaps not too much on the tariff reduction or the quick economic gain side, but yes, on the advancements of 21st century standard on a specific trade-related issues, including advancing coherent environmental, labor, and regulatory standards with our trading partners. And this also speaks directly to environmental and social demands phrased during the estallido. In the end, free trade agreements continue drafting the path of Chile in reducing social and economic inequalities. In any case, expect for sure TPP-11 issues to be widely discussed during the work of the convention. At the dawn of regained democracy in 1990, Chile consciously chose the path of global integration and open borders as a course for growth. And this provided for a number of years an outstanding economic performance in a wider perspective, boosting employment and growth, but also with many shortcomings, which are hopefully now being corrected by the convention and the future constitution. I believe an objective evaluation of what these treaties and international policies, which have been horizontal to the left and right-wing governments, have done for Chile, which of course has still insufficient but ongoing path to development, should be duly considered by members of the Constitutional Convention during the legitimate and much needed process of rewriting our Carta Fundamental. I share here Rosanna's half glass full room for optimism from my side. I think in keeping and improving international economic policies that have worked for our nation's development, but at the same time, of course, propelling that this economic progress now needs to be perceived and received by all Chileans.
Thanks, Cristian, and thanks to the panelists, not only for terrific presentations, but for sticking to the time, which leaves us a good half an hour for discussion. Before I launch into questions, I just want to announce that if you're interested in this issue of the constitutional reform in Chile, the Dr. Class Forum for a New Constitution in Chile, our next panel is a week from today. It's Tuesday, May 4th at 6:30 p.m. And the topic is why you should care about the rules of the game within the new constitutional convention in Chile. It should be very, very good. Okay, we've gotten questions from several different directions. I'm going to try to organize a few of them. I will present them to the group. If each of you could take 3-ish minutes to respond to the questions that pertain to you, that we hopefully get a second round in after that with Alicia, who's a lot smarter than me. So the questions will be even better. All right, here are a few questions. First of all, and this is mostly for Rosanna, but for anyone who wants to. First of all, how do you explain the extraordinary fragmentation of progressive forces, given that they had a fair amount of time to prepare for the convention, and given the potential stakes? How do you explain the fragmentation? And crucially, and this comes from Fran, who or what will coordinate progressive demands within the Constitutional Convention? There must be some discussion of this. What party, what actor, what organization, what mechanism will serve to coordinate, let's call them left of center demands? A question that I have mostly for Rosanna and Cristian, I suppose, is actually for all of you. How in the hell are Chilean politicians thinking about managing expectations? I mean, all of you in different ways have pointed to the potential risks of there being a gap between the expectations generated by the Constitutional Convention, by the potential expansion of rights, and the inevitable limitations of what is produced. If there's a risk, to democratic legitimacy of unmet expectations or dashed expectations, what are people thinking in terms of how to manage those expectations? Fran asked another question, which is more likely to be a flashpoint or a point of conflict in the convention: the demands for indigenous self-determination or demands for social rights that could potentially be fiscally costly. Which do you guys see as potentially more conflictual. June Ehrlich had a couple of questions. One is, what about Afro-Chileans? Have Afro-Chileans organized to have a voice in the new Constitutional Convention? And secondly, a couple of questions about the courts. June asked what the level of public confidence in the courts is today. Is it as low as the confidence in parties or in Congress? And if so, or either way, how does that affect the potential implementation of social rights? And are there any lessons to be learned from the Colombian case where you see sort of a large-scale politicization of rights enforcement? Finally, one other question from the audience, which is, does the exclusion, the non-inclusion of social rights from the Constitution limit the access to the courts by people seeking judicial review of actions taken by the government? In other words, in such a case, can the government simply argue that the absence of social rights renders these complaints or these petitions for judicial review beyond the jurisdiction of the courts? Why don't we go in the same order of presentation? So beginning with Dan, you guys should just take up the questions that you'd emailed them.
Thank you, Steve. So great questions. Too many for me to do in 3 minutes, but let me say something first about one of the things that Christian said, and that is this tension between sort of the demands of investors who want predictability and who want a certain sense of fiscal discipline and that sort of thing, and the social demands that are often reflected in social and economic rights. And I think one of the ways to think about that, which may or may not help in Chile, is that the move towards social and economic rights constitutionalism and toward in some ways, the judicialization of those demands was a response to that fear, right? So in the 1950s, the first sort of beginning, well, even a little bit earlier with the Mexican 1917 Constitution, but around the middle of the century, there were a lot of constitutions in Latin America that were incorporating these social demands, but then not creating strong judicial institutions to discipline them in a way, right? I mean, we think of them now, partly because of the Colombian experience, as courts as sort of the wild card or the loose cannon in the deck, on the deck, right? But in a way, right, the courts are also a mechanism for disciplining and balancing competing interests and that sort of thing. So in some ways, right, building in that strong layer of judicial oversight is one of the ways in which you can sustain this sort of commitment to the rule of law and predictability, and not kind of expose things too much to, immodest demands, I guess. But that does kind of raise the question, right? What about the Colombian case? How do you, and hasn't the Colombian case in some ways exploded expectations rather than limiting them? And in some ways it has, right? And in some ways the Colombian court has failed to produce the transformations that some people had expected. But I guess I have two thoughts on that. One is, when we look at what the Colombian Constitutional Court has accomplished, or what the tutela in general in Colombia has accomplished, and what rights in the 91 Constitution have accomplished, right? We have to kind of compare it to what we think would have happened in their absence, right? Not what people's hopes were necessarily, right? And so I think on a lot of these issues, particularly around indigenous rights and territorial autonomy and control over natural resource production and exploitation and so on, I think Colombia is way ahead of what we might imagine would have happened without that layer of judicial oversight and rights protection. So that's not to say they're getting everything right, but it's just to say that they've given voice to a lot of voices that were otherwise suppressed, including, in many cases, the voices of indigenous peoples. And so to kind of segue into the one question that I don't really know the answer to, but anyway, what's likely to be more conflictual, identity rights or social and economic rights, more sort of narrowly understood? And I think there's a sense in which indigenous rights have become greater flashpoints in many countries for two reasons. One is because they They challenge deeply held, long held social hierarchies, right? And they create spaces, decision spaces, where people who have perennially been excluded from the political system in Latin America have a voice, and not just a voice, but a strong voice, right? Through mechanisms like free, prior, and informed consent or consultation, or through regionalization, decentralization, territorial autonomy rules, or through the creation or the legitimation of communal justice systems or indigenous justice systems. So in that sense, right, they have given indigenous voices a much stronger role in deciding what happens in different parts of the country. And so that challenges not just kind of understood social norms and social hierarchies, but also very sort of centrally relevant economic interests, right? And so in that sense, right, they combine both kind of a sense of accepted social hierarchy and a threat to economic models, is particularly extractivist economic models that depend on natural resources that are often found in indigenous territories. So I think that's where the flashpoint is, not so much like how much healthcare should we get, or how much education should we get, or what does the right to housing mean.
Thanks, Dan. Yekana?
Yes, I want to add something to what Dan said about the Colombian case very briefly, and is that in the early 90s, healthcare coverage was around 20–25%, and nowadays Colombia has 96% of coverage in healthcare. And I know that coverage is not equivalent to access. There are several access problems, and that's why people go to use the tutelas, to get what they should. But I think that Colombian healthcare is much better today than it used to be, with all the problems it has. So the questions are really tough for 3 minutes, but I will try to manage. Regarding the question of who is going to coordinate all these demands after the green picture I put out there, this is what I want to believe, okay? I will give an optimistic answer. My optimistic answer is that, well, before that, context. I believe that the convencionales that are going to get finally in the convention will be those that are tied to political parties. I don't think that independent candidacies are going to do that well, or at least my colleagues who work on electoral issues, that's what they say. If this is the case, what I want to believe is that after these conventionals get to work in the convention, there is going to be probably a process of strategic adaptation in there, they will be forced to cooperate. And I think there is no other chance than trying to coordinate among themselves. But this is different from, trying to work on translating what people want into the convention. If you look, I am obsessed with the pictures and regarding the protest in Chile. One of the things that was really telling was that you couldn't identify in any of the marchas, in any of the protests, signs related to political parties. There was not even one. Not even the Communist Party, no party. The only symbol that was commonly seen was the Mapuche flag, which is also quite surprising. And I would like to know the take of Veronica on that, So there are a lot of negative political identities coming from citizens, and I think this is something that we should be researching much more, negative identities and how, because that seems to be the glue that stick them together in a way, Regarding Afro-Chileans, I don't have an answer for that, so I will try to make one up, and I might be utterly mistaken. But Afro-Chileans are around, well, we don't know exactly how many Afro-Chileans we have. Some calculations say it is around 4%. And then also a big chunk of the Afro world is tied to immigration and recent immigration. So I think that might be, I mean, because this is a very small community and because it's comprised also of immigrants, I don't know if they have been able to coordinate in a way. Trust for the judiciary is also quite low, but it's not as bad as for political parties. It depends on what public opinion poll you look at. It's between 13-15% to 25% in the past few years, and it has fluctuated a lot. So trust is low, but not as low as levels of trust you see with political parties. I will stop here.
Okay. Veronica, but
thank you very much. Thank you very much for your question. I will try to answer in English, so apologize for that. About how to compete with the center-right coalition, I think that the generation of alliances within the convention will be essential to position an agenda that considers the points that are shared by the progressive position, especially I think those that are related to the agenda proposed by indigenous peoples. I think that maybe reserved seats can act as a coalition, like an indigenous bench, I think, the bancada indígena, but it is also important to consider that the expectation for indigenous people are high. Perhaps we can reach agreements in a plurinational state, but not in autonomy. I don't know. I don't know, or maybe in self-determination, but not with a territorial expression. So I think that about the other question about what will be these key points in this discussion. For us, it is important, for us as indigenous people, it's important that our proposals remain in the Constitution. Maybe later, several laws will probably have to fulfill those aspirations. I think that we will have time for that. We have been waiting for over 200 years, but it is important that plurinational recognition is put in the Constitution. I think that maybe the strategy, or one strategy, is to position the idea that it will be impossible not to advance in the recognition of rights for indigenous people. En Spanish, creo que como se señaló, hay múltiples intereses que van a estar en juego, sobre todo económicos, políticos. La relación político-económica en Chile es muy porosa, y obviamente la industria extractivista tiene múltiples intereses en territorios indígenas. Entonces no se trata solo de la buena voluntad de reconocer los derechos de los pueblos indígenas, sino que hay implicancias políticas y sobre todo económicas, y sabemos que esa lucha, esa batalla va a ser compleja. Y finalmente, respecto del pueblo afrochileno, nosotros como pueblos indígenas y como pueblo mapuche en particular, lamentamos que el Estado colonialista chileno no haya considerado la voz del pueblo afrodescendiente en Chile, reconocido legalmente por el Estado de Chile. No pudieron obtener un escaño reservado en la convención, pero sí hemos asumido el compromiso como pueblos de recoger sus expectativas, sus voces en este tan importante espacio, si es que no acceden por la vía de otros mecanismos de elección, ya sea como independientes o como parte de los partidos. I'm sorry for that. I feel more comfortable talking in Spanish, of course, but thank you very much for your question.
No problem. That's why we have interpretation. We got to keep those guys busy. Christian.
I'll be brief, Steve. We have much time. I'll just pick up on two things. First, on very briefly on the trust for the judiciary. Exactly as Rosana mentioned, I think it's very low, and I honestly think it's undeserving in the case of Chile. Of course, there's corruption and there's issues everywhere in the world, but given and compared with the region, both the institution of the judiciary, the institution of the fiscales, the public prosecutors, defendants, and else, I think is an institution that in Chile more or less works, and I think it's undeserving the level of lack of trust which we have. I think it's actually one of the building blocks that we have in order to be a bit more to have our hopes a little bit higher up. Managing expectations, this full disclosure, I heard it from Andres Velasco on another Harvard panel. He was saying that a constitution is just a set of ground rules on top of which you write the policies, right? And if we have better politics, then we'll have better policies, and then we'll be able to address the issues. And he was saying, and I fully agree with this, that what stood Chile apart in the last 25 years or so, from the rest of Latin America, and where we'll be able to make the difference, is we actually had good politics. We have the same competition and parties, we had left and right wing governments, but we had a level of politics that, for example, we're able to have the savings that the state has today, which provides for another thing that gives me hope, which is our fiscal solidity. But I think the issue of managing expectations in a nation where no institution marks over the 15% is tremendously complicated, and we have to start to get our politics better.
Okay, I pass the baton to Alicia.
Great. I have so many questions for all of you, but we're going to do a quick lightning round because time is running out. So what I want to ask to everybody is simply, what is the key provision in the Constitution that we should be looking out for? Is there some article that you think, if it's included, could really help refound a new social pact, or if it's excluded would be a huge loss to the nation? And I think just relatedly, is there a political force that you think is going to come out of this really empowered and strengthened? So Dan, why don't you start us off with what's the key provision, and who do you think is going to come out as a winning political force?
Okay, so I'm going to duck a little bit because I think with a lot of things, right, it's not one gene that makes all the difference, but a combination of genes and how they work together, right? So I would say, I think there has to be attention. I think there has to be attention to, if I would put it in a category, sort of the decision spaces as much as to the substantive rights, right? And I include the courts in that. And so paying attention to how the legislature is structured and maybe escaños reservados as we were talking about earlier and so on, but also sort of the court and appointment mechanisms and sort of jurisdictional mechanisms for the court to be able to do the work of managing expectations. So I would say pay attention to the structures, even though we've been talking a lot about rights, pay a lot of attention to the structures. And then who's going to come out ahead? I mean, so here's one thing. I don't know the details of what representation is going to look like in Chile, as well as Rosana does. But here's one thing that I've seen in lots of different constituent assemblies around the region and in different parts of the world. And that gives me some hope. It doesn't happen all the time, but it happens in most cases. And that is, you don't need to be like an official veto player to matter within the Constituent Assembly, right? Being present often matters a lot. So for indigenous peoples in places like Guatemala and Argentina and elsewhere in Latin America, it wasn't necessary that they be the deciding vote, right? But it was important that they be in the room. And so in that sense, right, I think it will be necessary to build decision-making structures that are going to make it possible to write a coherent text, to get to the end of the day and approve something, right? But I think being in the room is really, really important. And so pluralism in representation, the efforts to include gender parity and reserve seats and that sort of thing, I think those are all really good moves that give me some hope.
Great. So we'll watch the rules of the game. Rosana.
Yes, well, these are very tough questions. It's a little bit of speculation in what I'm going to say. I think that something that we should expect, and that has been a lot of debate on that, has to do with qualified quorum and special majorities for the passage of legislation. And I think that's in a way the mother of all battles, because if you are able to lower a little bit the bar, you might be able to empower Congress, you know. So sometimes there were, for example, if you think of the healthcare reform of President Lagos, the first law project was intended to introduce solidarity, and that was vetoed, you know. And so you can put several examples of legislation that was in the right direction. I mean, and when I say right direction, I mean to say that it's close to citizens' preference, but they die because of a special majority in qualified quorum. So I hope that's going to be addressed. And I absolutely agree with Dan in terms of who will benefit from all this process, that, indigenous peoples, of course, because their voices are going to be heard, but also in terms of gender. I don't know if there are other experiences in the world of paritary conventions in terms of gender. That's Dan's field, so he might answer that question. But I think symbolically, this is going to be, I don't know, perhaps a bit of an acquired right, un derecho adquirido. I mean, even if it's not really a right, and even if it's only for the convention, it's going to be very difficult to go back from that, you know. So gender parity is I think is going to be in the agenda. So I'm glad about that.
Good optimistic note. Veronica.
Thank you very much. Well, very, very briefly, I think that for us as indigenous people, the key point, the key issue is the explicit recognition of a plurinational state. I think that is crucial because implies thinking all the Constitution in those terms, you know, from the right to the definition of the power, the redistribution of power. So I think that is crucial for us. And just about regarding the process, I think that it must be open, it must be transparent, and allow monitoring by society in all our diversity. Creo que ahí están los dos elementos claves, ¿no? Cómo discutir, y el Estado plurinacional estructurará todos los cambios a la Constitución. Muchas gracias.
Great, thanks, Christian.
I'm gonna first not answer and then answer. I think the key provision is probably the one we're not gonna have, in the sense that hopefully this stays as a minimalistic constitution, right? The experiences with very large and broad constitution that turn into a civil code also much more. We have a lot of those in Latin America, haven't proved very efficient. So hopefully we manage to keep the constitution as a framework in order to align the rest of the legislation of our country to our main and fundamental Carta Magna, right? Now, if you want me to go into specific provision, I think a lot of discussion is going to go into, and Chilean lawyers will get me here, into what is currently the Article 19, number 24 of the Constitution, which basically provides for property rights and for rights of use of certain property rights. And I'm just going to leave it at that, because otherwise we're going to start speaking about water and other things, and then we're never going to end. And in terms of I think, where do I see opportunity? I will say, I think all of them been mentioned, right? But in terms of gender parity, in terms of diversity integration, I think climate change, also a big one. Regions and the terrible centralization that this country is sick of, really, which is Chile. Who's able to put that also in terms of an economic opportunity, right? Not just say, oh, you know, this is the disintegrate. It's terrible about not the lack of gender parity, but how we actually turn that into positive and into, for example, with climate it's a very good example, into an economic opportunity. What Chile is doing today in terms of the shift to renewable energy is incredible. Not only in Chile, not only in Latin America, in the planet. We've gone from, you know, the highest prices of energy in the world 15 years ago to basically the cheapest through all green stuff. So I think trying to put things in terms of economic opportunity, it's going to be a win.
Okay. 3 points in closing. First of all, again, for those interested, our Dr. Class Forum for a New Constitution in Chile has a presentation, a panel next Tuesday at 6:30 on why the rules matter. Secondly, and most importantly, I want to thank our 4 panelists, Dan Brinks, Rosana Castiglione, Veronica Figueroa, and Cristian Rodriguez, for a terrific panel. And again, thank the audience and close the year and say we'll see everybody in the fall. And I look forward to beaming in from Dr. Class next fall rather than my living room. Take care, everyone. Stay well.